Good afternoon. Welcome. Daniel Bornstein, thank you very, very much for attending and being interested in this very important seminar. This information today is very cumbersome and challenging, not only to attorneys, of course, but also, of course, to people within the real estate industry. So I congratulate you for making the decision to actually participate. What I go through, I will go through rather rapidly. However, my hope is that you get a gut sense of what we're all up against throughout California as we continue to migrate through the COVID pandemic and the new rules and regulations that articulate and define landlord-tenant relationships in California as it relates to residential tenancies. So in this approximate hour-long webinar, I'm going to discuss the new rules and how you can best address these new rules to accomplish the goals you have for your real estate investments. So with that stated, it's again my pleasure to be educating you. Let's go over the agenda that I'm going to be providing to you at this time, so that we can know how we will evolve through this webinar. I'm going to go over key dates that you need to remember in order to best identify what you can and cannot do as it relates to rent debt. I'm going to emphasize July 31st as a core date where if you have non-payment of rent tenants, you've got to serve a notice. I'm going to talk about the revised 15-day notices that need to be issued between now and the end of September. And then we're going to talk about the nuances during the COVID pandemic that permits a tenant to remain in possession as long as they pay 25% of the rent debt that has accumulated through September 30th, 2021. I'll mention the just cause eviction protections that have been extended to all residential property until the end of September. We'll talk about October 1st as the light at the end of the tunnel, how we go about recouping rent debt through government assistance programs, an emphasis on the interrelationship between the state law and local moratorium. And then when we have COVID rent debt that hasn't been recovered through the state rent relief program, what are we going to do? And how do we use the state court system, whether it's small claims court or regular court, to secure those judgments that are due to us? And then, of course, as I always do, I'll mention the opportunity to discuss tenant buyouts in the event you are interested in negotiating a voluntary move out as opposed to pursuing litigation with a tenant. So that's the agenda. Let's jump to the next slide. 5 key components of AB 832 that you need to be especially aware of. And remember, AB 832 is the 3rd state law that addresses the COVID pandemic and landlord-tenant relationships. The most important right now for you folks who are taking this seminar is to make sure that before July 31st, you've got to send out a notification informing tenants of their rights. And if you don't have that document, at the end of this seminar or webinar, please email me and I'll be glad to send to you a template document that you can use. Also, tenants have until September 30th, 2021 to pay 25% of the total rent due to avoid evictions on grounds of non-payment of rent. Small claims courts have been expanded to allow for landlords to seek judgments against tenants for COVID-related rent debt that has not been recovered. And then AB 832 limits what local governments, whether it's San Francisco, Oakland, Berkeley, Alameda County, can do in asserting new rules and regulations as it relates to COVID-19 and eviction moratoriums. I do want you to understand that today I'm going over a state assessment of the law, not the particular rules of local jurisdictions. We're going to look at the state law and then follow up later on another webinar on the particular nuances of local law. For now, though, you've got to get a working knowledge of AB 832 in order for you to be comfortable on your knowledge base. Here's the emphasis. All tenants who have, as of July 1st, owe one or more rental payments due on or after March 1st, 2020, must be served an informational notice. This includes tenants who owe rent for this time period, have not yet received a notice to pay rent or quit, have received a 15-day notice but failed to return the declaration of hardship, or have also received a 15-day notice and returned the declaration of hardship. This document must be sent by the end of July. Service by mail is acceptable. If you want to be more diligent, you can post the notice on the door and mail it. You can personally serve it. But the general rule is no new 15-day notice can be served until the landlord complies with this requirement. So between today, the 27th, and the next few days, if you have not served that document, email me and I'm going to send it to you quickly. Get it in the mail to all of your tenants who have not paid rent during this period of time. If you don't do this, you are in potential risk of not being able to accomplish your goals later when you seek to recoup the rent debt that has accrued. Next, you need to remember right now, between March 1st and September 30th, if a tenant does owe you rent and you've served your July 31st informational notice, you can serve a 15-day notice to pay rent or quit. The only difference now is that you must include a blank declaration allowing a tenant to fill out and assert a claim of financial distress due to COVID-19. For instance, if a tenant hasn't paid you July rent and you serve a 15-day notice and you attach the declaration of hardship, and the tenant fills out that declaration simply by marking a box that they've been impacted by employment impact as a result of COVID, they lost a job, then they merely have to pay 25% of the rent debt that is accrued through the end of September in order to be entitled to remain in possession of the premises. The balance of the 75% of the rent debt is recoverable through small claims, but it is not something you can evict the tenant for. For your tenants who you believe are high income earners, you can request verifiable information of their income status, and that will help you discern whether you will be entitled to proceed on an eviction of that individual or not. And what we are talking about right now is the process to demand rent through a notice. This is not the state rent relief program. This is merely the law that permits you to serve a notice where you have no communication with the tenant, you have no indication of what's happening, and you're no longer willing to be patient. You can serve a 15-day notice right now. You can attach and must attach the related declaration of financial distress. And the likelihood, which is my experience in my office, is that tenants are completing them. And once they complete that doc, the ability to evict at this juncture is over, because now you have to wait until the end of September to see if they come up with 25% of the rent money due. Now, this law has also extended just cause eviction protections through September 30th to single family homes, and condominium units. So for those people in California who are outside of a local eviction moratorium or just cause eviction moratorium, and you own a single family home, let's say in Danville, the state law has extended just cause eviction protections through the end of September, which means prior to the pandemic, if you had a month-to-month tenant in a condominium and you wanted to terminate the tenancy because you wanted to sell the property vacant, you could simply serve a 60 or 30-day notice without a just cause. Right now, because of the pandemic and because of the extension of just cause protections for all units throughout California, you have to have a just cause to terminate. One just cause, of course, is demolition and substantial renovation, but now it's even more strict because in order for you to terminate at this point in time, it has to be necessary to comply with health and safety laws. It's not simply for a renovation of a bathroom or kitchen because you want to upgrade it. My strong suggestion is between now and the end of September, unless you have a real legitimate basis to need an eviction, wait until October 1st. The COVID protections for single family homes and condominiums are going to expire the end of September, assuming there is no extension, and we'll put an asterisk on that, but I would wait. I would wait because the optics of a termination at this point in time is not ideal. And two, we're only 60 days away from that core date of October 1st, where things start to change for us. Now, very important slide. Can tenants be evicted for non-payment of rent? I want you to look at the left hand of the slide. Rent owed between March 1st and August 31st, 2020. If a tenant has filled out a hardship document indicating that they've been impacted by COVID-related distress, they cannot be evicted for non-payment of rent. All that back rent does not get waived. It gets converted to consumer debt, which means you can proceed in small claims court. You can proceed in superior court, but you can't go through a non-payment of rent eviction for this period of rent debt. That's important. I know March 1st, 2020 seems long ago, but for people who are owed money, it's still painful, and you need to know what the rule is. For rent owed between September 1st, 2020 and September 30th, 2021, the rule is that if a declaration of hardship, that blank document, is completed by a tenant, the landlord cannot commence an eviction action for non-payment until October 1st. And if the tenant comes up with 25% of the rent due for this period of time, you cannot evict them for non-payment of rent. The remaining 75% of the rent is converted to consumer debt, and you can proceed in suing the tenant for the debt, getting a judgment for the debt, but you cannot use that 75% money to proceed with a eviction action. The public policy behind this is as follows. During COVID-19, the community and population of California has confronted a traumatic financial disaster. We don't want people to lose their housing because of it. We want to stabilize housing, reduce the risk of infection, and if someone in good faith fills out a form that says they've had a COVID-related impact and they pay you 25 cents on the dollar, you can proceed in collecting the remainder through the court process, but you will not be able to pursue an eviction of this person. Now, again, I want to emphasize, all of this discussion does not address the issue of seeking state rent relief, reimbursement for unpaid rent through the state. We will get to that shortly. For this slide, I just want you to recognize that some rent that's owed is never going to be used to seek an eviction. And that's important because pre-COVID, if rent debt was owed, you could proceed with the non-payment or rent eviction. We are now in a new world, a new reality. And again, congratulate yourself for being part of this webinar, because if I talk to 10 people on the street about these rules, 9 of them would have no understanding of it. And the one person who would have an understanding of it would have a misunderstanding of it. You two, or you folks, and there are now 333 people on this webinar, you folks are now in a greater position to be aware of the rules and insulate yourself from the mistakes that many people will make throughout California because they're not aware of the cumbersome nature of these new COVID-related rules. At fault just cause evictions for tenants under just cause. So here are the just cause evictions in California that you need to be aware of. A tenant violates the lease, commits a nuisance, commits waste, refuses to sign an extension, engages in criminal activity, sublets, refuses to let a landlord enter, uses the property for unlawful purpose, fails to vacate after landlord terminates employment, or fails to vacate after providing written notice of their intent to vacate. These are the just cause under the state law that we are now all operating under, with one big caveat. If your property is in San Francisco, in Oakland, in Berkeley, in other places where there are just cause eviction rules, you have to follow the just cause eviction rules. For those people on this webinar where you have property in other parts of California, whether it's a condo or a single family home, you have to follow this, especially until the end of September. I want you to recognize that the courts right now are in a very, very problematic situation. The problematic situation is that the courts, for many reasons, including difficulty securing juries, difficulty with shelter in place, loss of employees, the courts are terribly dysfunctional. I would not pursue evictions at this juncture unless we're dealing with egregious situations such as domestic violence, arson, drug dealing, and other criminal activity. For jurisdictions such as Alameda County, San Francisco, these are the sole types of evictions that have been permitted. Now, you can pursue other evictions, but I want to tell you, proceed delicately. And before making a decision to proceed, please make sure that you have consulted an attorney before you actually go forward with deciding to file an eviction action, because you will be terribly disappointed about how long it may take and how difficult it will be and how delayed it will be. I have cases that started pre-pandemic that I'm still working on because of delay. I have cases that have been set for trial that have been continued to January because there's no courtrooms available. So I want you to understand that any way you can resolve this by not proceeding with the court, such as a buyout of a tenancy, is something I strongly recommend. Now, no fault under the state law. A no fault eviction under the state law, owner move-in, relative move-ins, they're permitted. LSACs, where you permanently withdraw the rental unit from the housing market, they're permitted now. A red tagged building, where you have a building that has been injured or by a fire that's no longer safe, you can terminate at this point in time. And then I've talked about the intent to demolish or substantially remodel the property. Although remember, right now until the end of September, we are only going to proceed in that capacity where we have a public health and safety matter. Until September, my strong suggestion, unless there's an immediate need, you really want to delay in pursuing any type of evictions because we're still in the COVID pandemic. And unfortunately, with the arising or on the Delta variant arising, I'm very, very concerned that these rules will be extended for an additional period of time. I have spoken about small claims. Pre-pandemic, which is this slide, small claims was only available to businesses for $5,000 jurisdictional limit. If the amount in controversy for individuals was $10,000, that was the limit. And a plaintiff could file no more than 2 claims within the prior calendar year. However, now the new state law has unshackled small claims and made it an available remedy for unpaid rent that has arisen. So after the pandemic, hopefully October 1st, landlords who have COVID-related rent debt are allowed to proceed in small claims court regardless of the jurisdictional limit. Let me say that again. Landlords who have COVID-related rent debt, can seek to proceed in small claims court for that debt, even if that debt is over $10,000. There's no jurisdictional limit. The earliest date that you can file these lawsuits is November 1st, 2021. And because you're in small claims, there is no attorney representation. The good news is it's cheaper, it's faster, it can be more efficient. However, you don't get an attorney and you're on your own in the court. So if you're holding on to $30,000 of COVID-related rent debt and your tenant did not qualify for state rent relief, then the only alternative is to proceed in small claims court, assuming that tenant paid the 25%. There's a $30,000 balance. You could go to small claims court. For those of you who are property managers who have a portfolio of properties, or you're a larger landlord and you have 25 tenants who, after the end of September, you're still holding on to COVID-related rent debt, by November 1st, you could file small claims actions against your tenants. And when I talk about bundling, file all of the lawsuits at the same time so you have the same date for the hearing, so you don't have to keep running to court. And hopefully you have a quality judge in small claims court, you get your judgment, and you can pursue collections against that tenant. However, you've got to wait till November 1st. I also want to emphasize that rent debt does not need to be filed in small claims. You can file in regular court. Small claims, though, has no jurisdictional limit, but you are entitled to file in superior court. And the benefit of superior court is more due process, more deliberative process. You have the right to an attorney. Attorney fees are recoverable. There can be a cap on it, and you have more control over the process. My big concern for those people who have, hundreds of thousands of dollars of rent debt is that if you go to small claims court and you don't have an attorney and you lose, you're out of luck. In Superior Court, you have an attorney, you have a right to appeal. There are many ways in which you have more control over the process. It's more expensive, it's more time consuming, but for those of you who feel like you don't feel confident in small claims court, I strongly recommend that you consider filing in regular court. I want you to also recognize that COVID-related rent debt through litigation, you need to remember that before you can pursue a case, you have to make a good faith effort that you have sought state rent relief. You have to make sure that you have actively sought rental assistance for the tenant. You have to work with the tenant to secure funds from any government entity or third party. And what do I mean by that? I mean that the court is going to require you to sign a declaration indicating that you did pursue these avenues before they're going to permit you to evict. And what this means is increasingly, the role of a landlord is evolving with added responsibilities. Rental housing providers are now tasked with becoming credit counselors and social workers. And what do I mean by that? I mean that in the past, if someone didn't pay you rent, you could pursue a 3-day notice, you could pursue a lawsuit, you didn't have to go through a whole protocol. But because the public policy now is to ensure that you go and seek state rent relief before pursuing collections or evictions, you're going to have to provide documentation that in fact you have sought rent relief and sought the application before pursuing litigation. AB 832 makes it more difficult to collect the rent owed. Even if a judgment is obtained, remember, it is a piece of paper. Collecting the debt is altogether a different matter. AB 832 has 4 components that you need to be very aware of. 1, assigning rent debt that has accrued through March of 2020 and September of 2021 is prohibitive. Beginning October 1st, 2021, if rent debt could be sold or assigned to a third party, it's only permitted if the debtor does not qualify for rental assistance. When evaluating a rental application, you're not entitled to use COVID-related rent debt as a reason to deny a tenancy. And also, court records will be masked, so you will not be entitled to learn of whether a COVID-related rent debt arose with a tenant, so you're not going to know that information. You're not going to be able to use that information to deny an application. And civil courts will frown upon landlords who do not cooperate with tenants in seeking government assistance, and can even reduce damages when a landlord has not made good faith efforts to obtain rental assistance. So I've got to tell you, AB 832 really creates limitations on your rights. And before you pursue your rights, you should make sure you go through a protocol with an attorney to ensure that you have completed the necessary steps so you don't create liability for yourselves or you don't impact the quality of the judgment that you are seeking when pursuing rent debt collection from a tenant. October 1st. October 1st right now is the core date that we are looking at, because October 1st, things become more consistent with what our memory has been from the past. Currently, we're in that 15-day notice to pay rent or quit world. But as of October 1st, assuming the extension was not granted, assuming the law has not been extended, 3-day notices to pay rent or quit will resume. If a tenant fails to pay the rent within the prescribed period, a landlord can proceed with an unlawful detainer action. I do want you to know that there will still be specific language that must be provided in these notices. And also the notices must be translated into the tenant's native tongue if that's how they did business with you. My strong recommendation is you utilize English if you can with a prospective tenant, because it makes English be the core language that you interact with the person and makes things less cumbersome. However, the law is rather clear. Communication translations need to be provided to tenants if their native tongue is not English. And again, starting in October, to avoid eviction, the tenant must pay 100% of the rent, not just 1/4 of it. And remember, here's the real craziness. After a judgment is obtained, but before a sheriff effectuates a lockout, the tenant can ask the court to put a halt to the eviction if they can proceed and obtain approval for rental assistance. Armed with proof of a successful rental application, the court can delay things and determine whether the tenant has or will obtain state rent relief funds. What this means is that even after October, we're still going to be in a world of having to make a prudent decision as to whether we're going to proceed with a non-payment of rent case or not. My strong suggestion is that you, of course, seek state rent relief now. Make sure, as I've talked about at the beginning of this, you've got your July 31st letters out and that you are informed of how to go about applying for state rent relief. If you haven't done so yet, make sure you do so. If you need additional information about how to secure an application, email me. I'll provide you that. I want you to emphasize that it's much preferred that you seek state rent relief than you pursue a tenant for non-payment of rent in light of this new law and in light of the reality that the court scrutiny and tenant attorneys will be looking to see if you accurately, adequately, and properly sought state rent relief. And if you didn't, you may be hamstrung by your ability to accomplish the goal of either recovery of possession or securing monetary relief. A court will not issue a summons that seeks possession of rental property unless you attest under penalty of perjury one of two statements: that you've completed an application for government assistance to cover the amount demanded and the application was denied. For instance, a tenant doesn't meet the necessary criteria to qualify for state rent relief. They make too much money. And you also have to attach a copy of the final decision denying the application. So that's before you even pursue an eviction action, you're going to have to provide this under penalty of perjury, or you have a denial of the application, or before filing the complaint, the landlord submits a completed application. 20 days have lapsed. The landlord has served the tenant with the 3-day notice, and the landlord has not received or obtained verification from a government rental assistance program indicating the tenant has submitted or completed an application. There's been no cooperation from the tenant. What does this mean, folks? It means that before I can handle a non-payment of rent eviction for you, even after October 1st, you're going to have to show that you went through the process of seeking state rent relief. And you're going to have to file an application and a declaration under penalty of perjury stating that either there was a denial of the application, or in the alternative, the tenant simply refused to cooperate. For the last couple months, I've been working diligently with landlords and tenants, trying to get them to understand that there is a mutual benefit of submitting applications for state rent relief, and trying to cajole both tenants and landlords to complete the application in order for recovery of those funds. For the beginning of the program, I've been or beginning of the state rent relief program, I've been very disappointed about how slow, how cumbersome, and how difficult it has been to get the bureaucrats together to provide notification of whether we qualify or not. I've learned recently that more and more people are receiving information that their application has been successful, it's complete, and funding is occurring. So that's all good news. I hope it continues. The beauty of this new statute, AB 832, is instead of only receiving 80% of the rent debt, a landlord could receive up to 100% of the rent debt owed. If you've applied now and you're seeking 100% of the rent debt, you need not reapply. Also, AB 832 permits landlords to recover rent debt for tenants who have already left the premises. This is new. There are no forms, protocols, or procedures yet in place to submit this, but I want you to know that this is a new benefit, unlike the previous law. So you may be entitled to collect 100% of the rent debt through state rent relief. AB's impact. Landlords are entitled to 100% of the rent debt accrued on or after April 1st, and there's no fixed end date at this moment. For those landlords who have already received 80%, you need not reapply. You should be paid the remaining balance. Rental relief extended to households that no longer occupy the rental unit, as I've said, though no forms or processes have yet been established, and the criteria to qualify remains the same. You must meet income at or below 80% of the average median income for your region. If a tenant doesn't qualify, you're out of luck. And many of you are commiserating with me that you've applied and your tenant simply makes too much money. In that event, you're going to have to expect to receive 25% of that rent debt through the end of September, and you'll sue in small claims court or regular court for the remainder of that debt that has accrued. I want you to also understand, for state rent relief, different jurisdictions have different rules. And some municipalities are having hybrid programs. San Francisco has a hybrid program. You can apply through the state program, and there's also a local program. Oakland, eligibility is both through the state and local programs. Berkeley, eligibility is for a local program. Fremont, a local program, and Alameda County, a local program. If you are unaware of where to submit the applications, please email me. I will provide that documentation to you. If you haven't gotten the application completed and you don't have cooperation of your tenant, you are delayed. You should have already completed this. If not, do so immediately. Seek my assistance. I will not prepare the application for you, however, but I will provide you guidance on doing so. And the one big caveat is that you got to get tenant cooperation. And I've had clients who have gone to tenants' units with a Apple iPad simply to help them submit the application, because if you have tenants who are not sophisticated with technology, who do not have the wherewithal to handle an online application, it can be more cumbersome. There is scanning, there's uploading of documents. That's the easiest way to do it. There are other ways to do it, but you want to make sure that you don't lose the opportunity to submit an application, because as I've told you through this webinar, if you don't submit the application, you can be compromised in the future when you seek recovery of possession or you seek damages as a result of COVID-related rent debt. The new law, remember, very, very important. Landlords cannot charge additional fees for COVID-related rent debt. End arounds are prohibited. You cannot increase fees, such as charging additional parking fees because of compensation you seek for lost rental income. There are increased penalties for self-help eviction measures. You don't want to fall prey to taking your own initiative because you're so frustrated and you turn around and do something that's in violation of the law. If you do that, you're likely to be sued. And if you don't have wrongful eviction coverage, you're likely to have to pay for an attorney to defend yourself and also pay either the judgment by the jury or pay a settlement to resolve the matter. Tenant buyouts are still a viable option when you have a tenant who is in possession of a premises. They don't qualify for COVID state rent relief. They're thinking of moving to New York. They owe you some money. They're negotiating with you a voluntary move out. You have to make the decision. Is the vacancy with a cash flowing tenant more attractive than pursuing the existing tenant? And what are the costs to it? A cost benefit analysis is always prudent. And my strong recommendation is that when in doubt, reach out to me. I'm happy to dialogue about whether I think you should pursue a buyout or not. And I want to emphasize that if you're in Berkeley, in Oakland, in San Francisco, in Alameda, the city of Alameda, in Richmond, there are different rules for buyouts, so you need to make sure you follow the protocol. I am doing buyouts all the time. During COVID, there is no prohibition against negotiating a voluntary move out of a tenant, clearing out a vacancy, creating a vacancy. It's usually a win-win situation for both the tenant and you. And so there's no shame in pursuing it. Just make sure you do so consistent with the law. And any of you who are looking to learn about the law, just email me and I'll send you my packet so that you're prepared to handle any questions that could arise if you are pursuing a tenant surrender of possession agreement. That was a lot of information in a coherent manner. I ask you, my goal is education of the community, and my goal is to keep providing you information so that you can be aware and familiar with the rules. And my hope is that if you take a moment and provide a Google review, I greatly appreciate it. Of course, the more people who are aware of what I'm doing, the more people who can be educated about it. It's my commitment to you and the real estate community to keep educating so that you are familiar with the rules and don't create liability for yourself. As you can see, we are in a very, very confused, difficult time period. The laws have changed 3 times since March of 2020, and that's not taking into account local moratoriums. It's not taking into account county moratoriums. We're in a situation I've never seen before where an attorney has to stay abreast of the law and it keeps changing and there's very little guidance. We're not out of it yet. My hope is October 1st is that core date where we pivot and the light at the end of the tunnel arises. But I've got to tell you, this Delta variant causes me concern, and the landlord community and the tenant community may ultimately be at loggerheads and an extension occurs again. My hope is that it doesn't happen. I don't know that we have the stomach for it, but I think it largely depends upon how healthy our community gets. My core hope for all of you is that your family, friends, colleagues, our community stays safe, free from COVID, and that we can get through this together. And my commitment to you is to provide you the information, whether it's a July 31st notice that you don't have, whether it's information about state rent relief, whether it's information about buyouts, just ask me. I'm happy to send it to you. That's my commitment to you. Thank you very much for the opportunity to educate. For a replay of this, please, it will be uploaded on Facebook. We'll load it onto YouTube. Most importantly, Stay in touch. I will continue to keep you informed, and it's my privilege to be educating you about this very, very difficult situation. And I am committed to doing it again and again until we're more comfortable with the laws and we have greater clarity of what's happening. Thank you very much. Have a safe rest of the summer. And I will, of course, send you by email any of the docs that you request. Thank you and have a good day.